welcome back to the Constitutional Clarion. Now, one of the things as a constitutional lawyer that really annoys me is that when people talk rubbish about the Constitution. And as you can probably see by the progression of grey hairs, this has been happening quite a lot lately. Now, one thing that rather annoyed me when I saw it yesterday in a reputable newspaper was an article that dealt with Section 25 of the Constitution. Now, the thesis of the article was actually one I agree with, and that is that the Constitution itself is not a sacred document. It was written by real human beings who had flaws, that it is a relic of its time, and that we shouldn't be freezing our Constitution in the 1890s by making it unamendable. So far, so good. The problem comes to when there's a description there of Section 25, which no doubt the author made in good faith and genuinely believed. But this is what he said. He claimed that Section 25 of the Constitution is an appalling clause that now reads like something belonging to another planet, not just another polity, because it involves the total denial of political attention to an entire race. And then he went on to associate it with the idea of discriminating against Indigenous people. Now, let's actually have a look at what Section 25 does. But before we do that, we need to understand what the prior section, Section 24, does, because Section 25 relates directly to it. Now, Section 24 of the Constitution says that the two houses of Parliament are to be directly chosen by the people, and that the numbers of members chosen in the several states shall be in proportion to the respective numbers of their people. So what this means is that the number of seats that a state gets in the House of Representatives is directly related to its population and how that compares to the population of other states. So you may have seen this when it comes to redistributions. It may well be that one state gains an extra seat or two and another one will lose them because one state is growing in population and another state is reducing in population proportionately. So, for example, in the most recent redistribution, Western Australia gained a seat in the House of Representatives, and New South Wales and Victoria lost a seat. So that's how the system works. Section 25 then says this: for the purposes of the last section, that's Section 24, if by the law of any state all persons of any race are disqualified from voting at elections for the more numerous house of the Parliament of the state, then in reckoning the number of the people of the state or of the Commonwealth, persons of that race resident in that state shall not be counted. What does that actually mean? Well, it means that if a state discriminates against people of a particular race by excluding them from voting, that state is punished by having less representation in the House of Representatives. Yes, it is actually an anti-racial discrimination clause that was put in our Constitution in the 1890s. So how do we know it's an anti-discrimination provision? Well, we need to go back historically and trace it back to its origins, which is the US 14th Amendment to the Constitution, so part of the Bill of Rights. And that 14th Amendment was adopted in the wake of the American Civil War in 1868, and one of its purposes was to protect former slaves in the southern states to ensure that those states didn't discriminate against them. There are two sections from the 14th Amendment that are relevant here. The first section protects the privileges and immunities of citizens of the United States and says that no state shall deprive a person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction of equal protection of the laws. Okay, and that will probably be very familiar to you, the due process clause, equal protection of the laws. Then you have Section 2 of the 14th Amendment. This one penalises any state that denies or abridges the right to vote of any male inhabitant of the state who has attained 21 years of age and is a United States citizen, except when he has participated in rebellion or a crime. Now that penalty is that the representation of that state in the House of Representatives is reduced by the proportion which the number of excluded male citizens bears to the whole number of the adult male citizens who are inhabitants of the states. So in other words, it's doing the same thing as Section 25 is, and that is reducing the representation of the state in the federal parliament to punish it for discriminating against people's rights to vote. Now, one of the framers of the Australian Constitution was Andrew Inglis Clark. He was particularly interested in the United States Constitution and did his best to get provisions that reflected those two sections of the 14th Amendment into our Constitution. So if we go back to the 1891 Constitutional Convention, Andrew Inglis Clark convinced the Convention to include the following section. It would have said, "A state shall not make or enforce any law abridging any privilege or immunity of citizens of other states of the Commonwealth, nor shall a state deny to any person within its jurisdiction the equal protection of the law." Now, interestingly, it missed out the due process aspect of the first section of the 14th Amendment. And Inglis Clark later, when it came to the 1897 Convention, tried to get the Convention to insert that due process aspect as well as the equal protection of the laws. Now, Inglis Clark wasn't actually a member or a delegate to that Constitutional Convention, so he interfered by writing a memorandum and presenting it to one of the delegates to the convention. Unfortunately, when it came time to debate it, the relevant delegate had lost the memorandum and didn't really explain very well what Inglis Clark was trying to do. Second problem here was that it opened up the debate about all the other aspects of it that were already in the provision, equal protection of laws and reference to citizenship and all those sorts of things. And we'll see in the debate that occurred there, the delegates to the Constitutional Convention being concerned about the application of this provision. Barton was worried about the way the words of the amendment might be interpreted in the future. Eventually, in the course of debate, the provision was whittled down. In the end, all the provision did was give subjects of the Queen, who are resident in a particular state, protection against discrimination by another state. That's what it ended up from all of this, equal protection, due process of law, chucked out, and all we ended up with was Section 117 of the Constitution. Now, Inglis Clark was more successful in dealing with the second section of the 14th Amendment and getting the Constitutional Convention to adopt that. So he convinced the Convention to adopt a provision which would penalise any state that discriminated on the basis of race against people from voting, so that the representation of that state would be proportionately reduced in the House of Representatives. Now, interestingly, if you compare Inglis Clark's provision to the US provision, Inglis Clark's one specifically refers to race and discrimination on the basis of race, whereas the US 14th Amendment actually refers to discrimination in voting rights against adult males. Now, this was raised during the convention debates because one of the members pointed out that in Western Australia, for example, there was a property franchise. So could you extend it so that it protected the right to vote against people who were being excluded from the right to vote on the basis, for example, of not having the required property requirements? Now, when that point was made, one of the convention delegates pointed out that, well, Western Australia had the guarantee of a minimum of 5 seats regardless of its population, because that guarantee was given to all original states. Western Australia would therefore probably not be affected by this provision until such time as its population grew so it exceeded the minimum 5 seats that it was guaranteed. The interesting thing about that, by the way, is that no one actually thought about, well, what about discrimination against women on the basis of their not being able to vote? Should that be a basis of Section 25? And I find it quite interesting that in the 1890s, it was acceptable to have an anti-racial discrimination provision put into the Constitution, but not one that dealt with discrimination against women and their voting rights. Women's voting rights were a very hot issue at the time, and it seems that they did not want to address it. Indeed, in fact, there's a provision in section 128 which goes in the reverse direction, and that says that until there is a uniform franchise across the Commonwealth, any state that has universal suffrage, so women being able to vote, would have its vote divided in half for the purposes of counting up majorities in a referendum. So what does all this history tell us? Well, it tells us that Section 25 of the Constitution is an anti-racial discrimination provision. It's not an appalling racist provision, as it is sometimes described. I doubt very much that any American would think that the 14th Amendment of their Constitution was an appalling racist provision. Section 25 is clearly no longer appropriate because it does contemplate the possibility that a state could exclude people from voting on the basis of race. It's no longer necessary, and therefore it is appropriate for it to be removed from this Constitution. Indeed, there's been a couple of goes at getting rid of it. So the first time was back in 1967, at the 1967 referendum. Now, you'll remember that the successful 1967 referendum question involved dealing with the race power, altering that, and removing section 127 of the Constitution, which deals with the exclusion of Indigenous people from the reckoning of the population for certain purposes. It didn't address section 25 because there was a second referendum held on that day. That referendum proposed to change section 24 of the Constitution to remove the nexus requirement between the size of the houses, which requires that the House of Representatives be twice the size of the Senate, and would also have repealed sections 25, 26 and 27 of the Constitution. Now that referendum failed, the consequence that section 25 survived. There was another go in 1974. On that occasion, the Whitlam government proposed to require one vote, one value at state elections and to put in provisions concerning that. And that also would have included the repeal of section 25 of the Constitution. But that referendum failed as well. That takes us up to 2012 when the expert panel on the recognition of Indigenous people in the Constitution gave its report. It also recommended the repeal of section 25 of the Constitution, and that was the least controversial thing of all the recommendations that it made. But later on, with the process of having the regional dialogues that led up to the Uluru Statement from the Heart, that provision about repealing section 25 from our Constitution seemed to get dropped. So it's not mentioned in this particular proposed referendum that we're voting on at the moment that deals with the voice, that concentrates solely on the voice and would leave section 25 there. Section 25 therefore sits with a mixed legacy. On the one hand, it is an anti-racial discrimination provision. It is a small remnant of the US Bill of Rights that sits in our Constitution, but it's also a reflection of the 1890s, a time when a state could contemplate excluding people from voting on the basis of race. And that takes us back to the original point of that particular article, and that was that we shouldn't treat the Constitution as sacred. The Constitution was written at a time when people believed different things and had different standards, and society was quite different. And it's just not the time that we live in now. Our Constitution does need to reflect the life we live, the society that we live in, the expectations that we have of ourselves and others, because otherwise, if we freeze our Constitution in the 1890s, if we treat it as sacred and unamendable, we'll end up with a Constitution that is so different from our lives and our expectations that whenever it becomes stressed in the future, it will shatter to our detriment. Now, thank you again for listening to the Constitutional Clarion. I hope you learnt something useful about Section 25 of the Constitution, and I look forward to seeing you next time. Goodbye.